Good afternoon and welcome to the Judiciary Committee. My name is Steve Lathrop. I'm from Omaha representing Legislative District 12 and I chair the Judiciary Committee. On the table inside the doors when you came in, you'll find yellow testifier sheets. If you are planning on testifying today, please fill out one of those yellow sheets and hand it to the page when you come up to testify. This helps us keep an accurate record of the hearing. There is also a white sheet on the table if you do not wish to testify, but you would like to record your position on a bill. Also, for future reference, if you're not testifying in person on a bill and would like to submit a letter for the official record, all committees have a deadline of 5 p.m. the day before the hearing for submitting those letters. We will begin bill testimony with the introducer's opening statement. Following the opening, we will hear from proponents of the bill, then opponents, and then finally anyone speaking in a neutral capacity. We will finish with a closing statement by the introducer if they wish to give one. We ask that you begin your testimony by giving us your first and last name and spell them for the record. We utilize an on-deck chair to the left of the testifier's table, and in fact we have an on-deck row up here. So as we get going, when we're on proponents or opponents, if you would come up to the front and fill up the chairs so that helps us keep the hearings moving along. If you have any handouts, please bring up 12 copies and give them to the page. If you don't have enough copies, the page can make more for you. We will be utilizing a light system, and if you haven't done this before, these are the lights I'm referring to. The light on the table will turn green. That will be green for 2 minutes. Then it'll turn to yellow. That's your 1 minute warning. So you get a total of 3 minutes to testify. If you brought prepared testimony and you have more than 3 minutes worth of testimony to read, you might want to pare it down. Because when the light comes on red, we'd ask that you wrap up your final thought and stop. You may get questions from committee members after you stop your testimony. As a matter of committee policy, I'd like to remind everyone the use of cell phones and other electronic devices is not allowed during public hearings, though senators may use them to take notes and stay in contact with staff. At this time, I'd ask everyone to look at their cell phones and make sure they are on the silent mode. Also, verbal outbursts and applause are not permitted in the hearing room. Such conduct may be cause to have you excused from the hearing room. You may notice committee members coming and going. This has nothing to do with how they regard the importance of the bill before the committee, but senators have bills to introduce in other committees or may have other meetings to attend. We are holding our hearings in the Warner Chamber, as you all obviously know. While our regular hearing room is being renovated, please remember water bottles, soda cans, and cups are not permitted on the desks, and that's to avoid any water damage and stuff like that. Assisting the committee today are Lori Volertson, our committee clerk, Neil Erickson and Josh Henningsen are our 2 legal counsel. The committee pages are Elisa Lund and Dana Mallett, both students at UNO. And finally, I'll have the senators that are on the panel introduce themselves, beginning with Senator Wayne.
Senator Wayne, out of District 13. I had to pause and think of what I was saying. I thought I was testifying, sorry. I was going to spell my name and everything. District 13, which is North Omaha, Northeast Douglas County.
Julie Slama, District 1, Otoe, Johnson, Nemaha, Pawnee, and Richardson counties.
Adam Moorfeld, District 46, Northeast Lincoln.
I'm Patty Pansing-Brooks, District 28, right here in the heart of Lincoln.
Tom Brandt, District 32, Fillmore Thayer, Jefferson, Saline, and southwestern Lancaster County.
I'm Wendy DeBoer. I'm from District 10, which is Bennington and the surrounding areas, and northwest Omaha.
And with those introductions, we will begin with our first bill, and that will be LB 478, and brings us to Senator Vargas. Welcome, Senator Vargas.
Thank you very much, Chairman Lathrop. Members of the Judiciary Committee, I said this earlier to Chairman Lathrop that I know this is a loner room and apparently it's a little hot, and I'll try to keep this very brief. I'm here to testify My name is Tony Vargas, Tonyvargas, and I'm proud to represent District 7 of downtown and South Omaha. I'm here today to introduce LB 478, a bill that prohibits the use of consent by a minor as a defense, mitigation of damages, or liability in certain civil actions arising from sexual assaults. Now, this testimony is pretty straightforward. I'd hope that this is an easy principle to vote on. Boiled down, the premise of this bill is this: it should be easy to say that an 8-year-old cannot provide consent to a person of authority, and it should be equally easy to say that a victim and their family should not be further victimized by a statutory framework that can result in the defense victim blaming their way out of paying damages. However, the way our current statutes are written, it is allowable. And in some civil cases stemming from sexual assaults, for the defense to say that a child consented to sexual activity and therefore shared culpability exists between the child and the perpetrator. Now, you may be asking yourselves if this really happens in Nebraska. The sad answer is yes, it does. The issue was brought to me by a constituent who has experienced the harmful repercussions that this defense can have on a victim and their family. Now, because their case is ongoing and in the interest of their respect and privacy, I will not delve into any specifics. But I can tell you that across the nation, there have been horror stories of proceedings where the defense is in effect engaged in the victim blaming of young children. And I'm actually going to hand out a couple of different articles for your reference before I dive a little deeper. So for instance, a court in Florida found that 4 third graders were careless and negligent, quote unquote, and old enough to know better when a teacher molested them. Right now, there is nothing in Nebraska statutes that stops victims in civil cases from being blamed under a defense known as comparative negligence, the basis of which is reliant upon establishing consent. Now, comparative negligence splits the responsibility between the victim and the party accused of negligence. This technique can then be used to reduce how much is paid to the victim. While this defense may have its merits in certain instances, it certainly has no place in shifting the blame onto the child victims in our state. Several states have begun to take action on issues similar to this. States like California very recently take legislative action, while others have left this issue to the courts to decide. However, I don't think we can afford to do the latter. It is clear that the courts have not adequately dealt with these defense practices as Nebraskans are still being impacted. I want to be clear that this bill does not shift the burden of proof or any other standard operating procedures in courts. It simply forbids only one defense. Now, there will be a few individuals that have submitted testimony or will be testifying in support, a few of which including the Nebraska Association of Trial Attorneys and Voices for Children. But I want to reiterate this specific point. It should be easy to say that a third grader cannot consent to sexual activity. A third grader cannot be careless and negligent or old enough to know better when a teacher molests them. We have a duty as elected officials to protect the most vulnerable among us, and I am happy that this committee has shown a willingness to do this session. It is my hope that we can continue to work together to advance this bill out of committee and protect victims from further being victimized. With that, and I just want to thank you, the articles that you have in front of you provide a lot more instances that you see across the country and examples of some of the different testimony and language that is used to do some of this sort of shared negligence. I'm also going to enter into the record here to pass out a letter of support from Voices from Children supporting this bill. And with that, I'm happy to answer any questions you may have.
Senator Brandt.
Thank you, Chairman Lathrop. Thank you, Senator Vargas, for bringing this bill. Just a point of clarification, it's very obvious to me third grader is not going to provide consent. Is there an upper age limit on this bill? I mean, does it go all the way to 17-year-old?
Yes, this is up to 17, under 18 years of age.
Okay, thank you.
Okay, I don't see any other questions. Thanks, Senator Vargas.
Thank you very much.
If you intend to testify, if you wouldn't mind coming up to the front row, in the on-deck circle, if you will.
Thank you.
Good afternoon.
Senator Lathrop, members of the committee. For the record, my name is John Lindsay, Johnlyndsay. Appearing on behalf of the Nebraska Association of Trial Attorneys in support of LB 478. As you heard in the opening, the bill came from a constituent of Senator Vargas's. We did not, it's not our, I want to make clear, not our bill, but we saw this and said, wow, that's a hole in the law that we have not recognized before. So we appreciate Senator Vargas bringing this to your attention. I want to make clear the operative portion of the bill is the first 5 lines of the bill. And that is where it provides that consent by a minor cannot be used as a defense to try to establish contributory negligence or comparative fault. And I think to make clear that before you even get to this, each element of the defense must be proven by the plaintiff. So it's not a burden shifting or anything like that. It's that the question, when defense brings forward their defense, they can't use to mitigate or to provide as comparative fault or to provide as an affirmative defense to a case that a minor consented. Under 28.319, the Nebraska Legislature for years has said a minor under the age of 16 is incapable of consenting. It would be absurd to say, we've determined you cannot consent, but your consent can be used against you. So we do believe that illegal activity on the part of the perpetrator should not be available to help the perpetrator out of the problem that he or she has created. In answer to Senator Brandt's question, as we read the bill, yes, would extend to 16 and 17-year-olds because 28.319 does not, well, 28.319 does not cover those who are 16 and 17. They can consent, but the bill does cover them under the portion, the remainder part of the bill deals with undue influence in a position of authority, and whether that's a coach, whether that's a minister, whether that's a teacher, somebody who is in a position of authority and knows better than to abuse that position, to abuse a child. We would be happy to answer any question, and we would urge the advancement of the bill.
I don't see any questions. Thanks for being here today, your testimony. Anyone else here is a proponent of LB 478? Anyone here to testify in opposition? Anyone here to testify in a neutral capacity?
I am 2 copies short. Okay, thank you.
Good afternoon.
Good afternoon. My name is Billie Douglas, Billiedouglass, and I'm here today to testify neutral on LB 478. While I absolutely support the very beginning of LB 478, Section 1, which you all have copies, so I won't read verbatim at this moment. However, I would stop it as the perpetrator was an adult. Because LB 478 does not stop there, that's why I can only remain neutral. Due to how it specifically sets guidelines for how an adult would be considered in a position of power, I sit here in front of you today stating that anyone who's taking advantage of a minor should always be considered to be in a position of power. If that person is picking up that minor in a car, that adult should be considered to be in a position of power. Just because they are not a coach, a teacher, or an official doesn't mean they are not in a position of power. When I was 13 years old, I was invited to a park over Facebook by a 20-year-old man. He drove to that park in a car that he paid for and had licensed each year so he could meet me and have sex. He did this not only to me, but a 15-year-old as well. And who knows how many victims before that who decided not to come forward. I was only 13, his second victim was only 15. This person was not our coach, he was not our teacher, he was not our relative, he was a 20-year-old adult. This bill would not have applied to him. He could have claimed since we consented, he should have not been held liable, and he would be right in that defense. I run an after-school club right now, and I teach middle school boys and girls about history for an hour a week. I look at their faces, I look at their excitement, I look at their trust. While this bill might protect them from teachers and coaches, it wouldn't save them from a person online that isn't a teacher or a coach. This bill, if enacted, could send a dangerous message. It says that if you are just someone off the street or online that you thought that the victim thought they could trust, you're no longer protected. Even though you were too young and too fearful to say anything, this person could use that against you and testify and said that it was okay, even if you were just 13. And that would be liable since they weren't under this specific position of power. When it comes to safety of children, I don't like putting specifics on who is or who is not worthy of their respect and trust. Whether it be a 20-year-old teacher or a 20-year-old driving a car, they both should be considered to be in a position of power. Enacting LB 478 with the current language in regards to what defines a person in a position of power sets a dangerous precedent. If you're a teacher, you cannot do these things. If you're not a teacher, you can do these things and possibly testify and that they consented and can possibly free yourself from any wrongdoing. I ask you to consider strongly adding a committee amendment to LB 478 to change this language. And I thank you for your time.
Thank you. I appreciate your testimony. Senator Pansy Brooks.
Thank you for coming, Ms. Douglas. Did you talk to Senator Vargas about this?
I called his office the other day, and they did mention that the person I talked to in the office referred to, I guess they weren't quite sure how to answer the question at the time, and I did want to bring it up a little bit earlier, but I am in support of this, and hearing, I guess, the proponent that testified a little just before me, it is important for the 16 and 17-year-olds who are considered an age of consent for a teacher. I guess I would also, just considering that gap, though, is my biggest thing in regards to minors. So I wanted to talk to, and I should have taken more time, and I recognize that.
And it does include that it defines adult as one that, or that a position of authority is defined as those various titles of adults, but it does say including but not limited to. So it can extend, I believe, to others, but anyway, maybe you could speak with his office again.
Okay, yes, thank you.
I don't see any other questions, but thanks for coming down here today. Anyone else here to testify in a neutral capacity? Seeing none, Senator Vargas, you are free to close. We do have one letter of support from Mary Sullivan at the National Association of Social Workers.
Chairman Lathrop, members of the Judiciary Committee, I want to thank you. I said we want to really be brief. I think there's a lot of things that we can agree on, and I think this bill addresses a gap, and I just want to provide a little bit more clarity. So in at least 8 states, we'll be able to find Colorado, Massachusetts, Oregon, Pennsylvania, South Carolina, Washington, and Utah have passed some level of legislation change to remove this line of defense. We would not be alone in this. Others have done it through litigation. And to be clear, this bill does not shift the burden of proof or any other standard operating procedures in courts. It simply provides this one type of defense. And I hope we can all agree this defense, this mitigation of damages on civil actions from sexual assaults and this victim blaming is not a pathway that we want to be able to allow in the state of Nebraska under these circumstances. So thank you, and I appreciate the time.
Very good. Thank you, Senator Vargas. That will close our hearing on LB 478 and bring us to LB 519, Senator Slama's bill regarding statutes of limitation. Before you start, you want to change that little tint there. Perfect. Thank you.
Absolutely. Okay, good afternoon. Oh, we good?
Yep, we're good.
Good. Good afternoon, Chairman Lathrop and members of the Judiciary Committee. My name is Julie Slama, Julie-Slama, and I represent District 1 in Southeast Nebraska. LB 519 extends the statute of limitations for human trafficking and child pornography and also allows law enforcement officials to seek a wiretap order to investigate allegations of human trafficking. Human trafficking is the fastest growing criminal industry globally. It was made a federal crime in 2000, and Nebraska likewise made it illegal in 2006. In the years that have followed, lawmakers have tried to give law enforcement officials the tools they need to crack down on this horrendous crime. Nebraska, unfortunately, is part of a regional and national system of human trafficking. With I-80 running across the state and I-29 running along our most populous city, Omaha, human traffickers are active, and most Nebraskans are none the wiser. Human trafficking doesn't just impact our big cities. Cities and towns across Nebraska, like North Platte, Hastings, Grand Island, Sidney, Lexington, and York, see trafficking as well. Just this past weekend, there was an article in the Kearney Hub shedding light on the problem in Kearney. It happens in truck stops and hotels, and it's happening right now somewhere in Nebraska. The internet accounts for 25 to 33% of trafficking cases discovered. The average age for someone to become a victim of trafficking is 16. There are many factors that play into why a person is vulnerable and ends up a victim. Those factors include poverty, family dysfunction, sex abuse, or a feeling of isolation in their community. Many people who become victims of human trafficking report that traffickers made them feel loved, like they belong. They shower the victim with gifts, food, and a place to live, but all these things that make the victim feel loved and accepted come at a steep price. The need to crack down on these traffickers is great. Trafficking is expanding and growing industry because there's a perception among traffickers that they just won't get caught. They find there is little risk in trafficking because of a lack of strong penalties, a low risk of arrest, a lack of public awareness, and knowledge that they can threaten or bully their victims into not reporting the crime. Again, many people are unaware of how frequent this crime is happening because it's an out-of-sight, out-of-mind crime. The victims of human trafficking need to feel that they can come forward and report the crimes against them. However, many victims feel shame, embarrassed that they were trafficked. Many victims fear retaliation or violence against them or their families by their traffickers if they do report. Many also have a lack of trust in the system or in our law enforcement. And the effects of beatings, rapes, and abuse can stay with the victim long after they are removed from their trafficker. By the time these victims report the crime, the statute of limitations has elapsed and charges cannot be filed. Because of these reasons, I have introduced LB 519. The statute of limitations in LB 519 will be extended to 7 years for a trafficker of an adult for labor or sex trafficking, or within 7 years after a victim's 18th birthday. It will also apply the same statute of limitations to those who benefit from labor or sex trafficking. For a person who has been found to be in possession of child pornography, the statute of limitations for that crime will also be extended to 7 years, up from 3 years, or within 7 years after the victim's 18th birthday. For a trafficker of a minor for labor or sex trafficking, there will be no statute of limitations applicable for the prosecution or punishment of said trafficker. The changes I make in LB 519 will apply to offenses committed prior to the date to offenses committed prior to this date whose statute of limitations have not yet expired, and to those offenses that occur on or after the date this bill goes into law. Finally, because finding these traffickers and getting them behind bars for their crimes is so important, I've included language that would allow the Attorney General or any county attorney the ability to obtain court approval to wiretap for investigation purposes for labor or sex trafficking of both adults and minors. The AG and county attorneys already have this ability for other serious felonies. Approximately 47 Nebraska schoolgirls are trafficked each year through exploitation by force, fraud, coercion, and deception. Human trafficking is modern-day slavery. We need to be able to help the victims of human trafficking and allow them time to heal and feel comfortable about reporting the crimes that occurred against them. We also need to ensure that law enforcement have the tools necessary to crack down on human trafficking. LB 519 serves both purposes and comes with a zero fiscal note. As such, I ask for the committee's support of LB 519. Thank you, and I will answer any questions that you may have.
I do not see any questions, Senator Slama.
Thank you.
Thank you for introducing that bill. I will take proponent testimony. Good afternoon.
Good afternoon. Good afternoon, Chairperson Lathrop and members of the Judiciary Committee. My name is Anna Brewer, A-N-N-A-B-R-E-W-E-R. I was employed as an FBI special agent for just over 20 years, and I currently lead the Nebraska Attorney General's Office Human Trafficking Task Force. I come here today as a representative of the Attorney General's Office in support of LB 519. My testimony will focus on the wiretapping provisions of LB 519. Corey O'Brien will follow me to speak on the statute of limitations provision of this bill. As a law enforcement officer for over 21 years, I have investigated over 200 criminal investigations. The majority of my work has focused on crimes against children and violent crimes. I established and managed the FBI's Child Exploitation Task Force, which had the primary responsibility of investigating child sex trafficking. In my career, I have trained over 20,000 law enforcement officers, healthcare providers, attorneys, educators, and other professionals on sex trafficking and violent crimes. Sex traffickers commonly use electronic devices to advertise children and vulnerable people for sale, and often communicate with sex buyers to arrange the sale of children and other vulnerable people. In addition, sex traffickers often communicate via electronic devices to direct, manage, and control the people that they exploit. Being able to intercept these communications will enable law enforcement officers to collect and prove or disprove, disrupt, and dismantle the criminal enterprises that engage in human trafficking. It is important to note that human trafficking in essence has three components: the trafficker, the buyer, and the victim. If we are able to intercept communications, we are not only able to hold the trafficker responsible, but we are able to identify the buyer and prevent another child or vulnerable adult from being the victim of a sexual assault. The end result would be to hold the trafficker and the buyers accountable, as well as emancipate and recover the victim. The combination of the three is the goal of the intercept of the communication. Electronic intercept is not the first investigative technique to be used during the investigation. There is a pathway or a trajectory in the investigation that will lead to this use of the investigative technique. After having exhausted less intrusive techniques, I would opt for the electronic communication interception. Having the ability to use this technique when appropriate is an invaluable tool. For example, I am currently investigating a group that has been communicating using electronic devices. This group has been recruiting teenage girls from local high schools in the greater Omaha area and luring them into sex trafficking. In this investigation, if I had the ability to intercept their communications, I would have been able to rescue at least 20 females from daily sexual abuse and rape. I would have been able to identify the traffickers and arrest the buyers. There is no better evidence than one's own words. Oftentimes, persons who are trafficked do not self-recognize as a victim of these crimes, and it is not until much later that their victimization is identified. In my experiences, the average duration of a federal investigation is 2 to 3 years. One must take into consideration all of the resources. Thank you very much. I would welcome any questions.
Okay. Senator Chambers.
Yes, sir.
Mine relates to the language of this, and I know some of it tracks existing law, but by mentioning that the indictment is found by a grand jury, that doesn't mean only a grand jury, correct?
I would defer to my prosecutors and legal experts regarding the legalese. Okay. Thank you, sir.
Senator Pansy Brooks.
I'm just going to take this moment to thank you for your incredible work over the years on trafficking and helping to save the lives of really vulnerable people. Also, the work of of Attorney General Peterson and the Women's Fund and others like the Nebraska Family Alliance and others that have worked so hard to really protect very vulnerable Nebraskans. Thank you.
Thank you.
I see no other questions. Thank you, Ms. Brewer. Good afternoon.
Good afternoon, Chairman Ashford, members of the Judiciary Committee. My name is Corey O'Brien. That's C-O-R-E-Y-O''Brien, and I'm the Criminal Bureau Chief of the Nebraska Attorney General's Office. I appear here today on behalf of Attorney General Doug Peterson and the Nebraska Attorney General's Office in support of LB 519. As Senator Slama so eloquently put in her opening statement, there are two primary purposes for LB 519. The first is to extend the statute of limitations. It would extend the statute of limitations for 7 years when it involves adults that are victimized by these offenses. And it also extends the statute of limitations for possessory crimes of child pornography. The second change made to the statute of limitations proposes to impose no statute of limitations when the victim of the sex trafficking is a minor, and also makes a change to the child pornography laws when the crime being committed is the actual manufacture of child pornography, so that there would be no statute of limitations when the victim was the subject of child pornography that was made. As Senator Slama pointed out, it is so difficult for us to uncover both of these crimes within the statutory period currently available of 3 years. In many cases we can, but in a lot of cases we can't put all the pieces together. And it's not necessarily justice to make these victims not whole again or have any recourse in these particular kind of cases because of the failings of law enforcement not to properly be able to have the tools to find all these allegations and these crimes within a 3-year statute of limitations. The second component of the bill is what my colleague just testified to, and that being adding human trafficking offenses to the offenses for which we can do wire intercepts. As Ms. Brewer pointed out, we are working an extensive human trafficking case that is very pervasive. And it's been very frustrating at times that we did not have that tool in our tool bag, particularly when we know that many of these human trafficking operations that we investigate are operating using cell phones and social media. This particular case, there's extensive use of social media that would have allowed us to shut down this organization over a year ago, had we had that ability. So we thought it fitting that this kind of crime warranted inclusion under the intercept statutes, given the fact that it is so dependent upon electronic communications in order for them to commit their offenses. With that, I would certainly entertain any questions the members committee have on this bill, but we'd ask you to send LB 519 to the floor. And if you have any issues with the bill, we'd certainly be willing to discuss those and try to resolve those.
Okay, thank you. Senator Chambers.
Mr. O'Brien, as I had indicated, this language follows existing law, but why does it say within 6 months or 7 years if a grand jury brings an indictment? That's not the only way that this can be implemented, is it?
No, sir. There's a separate statute that allows county attorneys and attorney generals to bring charges by way of information in addition to a grand jury. So that language is probably in need of some update.
And that's for the record. Now, it does say, it mentions the magistrate. Who is the magistrate under Nebraska law? Would that be the same as a judge?
I believe that under, again, some archaic language, it's referring to judges, but we actually do have clerk magistrates that serve throughout the state of Nebraska. A lot of times they're glorified clerks of district courts, but I think that what was intended there was probably courts, and in my opinion, it should be limited to judicial officials to be described as magistrates.
So are you saying that a complaint of this kind would be filed with the magistrate, with the clerk magistrate?
Or the clerk of the court.
Well, this doesn't say clerk magistrate, it just says magistrate.
I know it doesn't. So.
Would it be a problem if this language was modified, even though some of it is in the existing law? I haven't read every criminal statute, by the way, and I've become aware of some things when they are not directly at issue in the bill that's brought to us. But that's something I can talk to you about later. I just wanted it to be brought to your attention, and you can be thinking about it.
I don't think it's a crucial part of the bill, and certainly any language to modernize Nebraska statutes, I'm always in favor of.
I don't have anything else. Thank you.
Hang on one second,
sorry.
because I do have a question.
Yes, sir.
For one of these, we're going to eliminate the statute of limitations?
It's actually for 2 offenses, and the first being sexual trafficking or labor trafficking of a minor.
Of a minor. We would just completely get rid of the statute of
There would be no statute of limitations.
Tell me right now, in what crimes fall into that category where we have no statute of limitations?
Normally, murder.
Murder, that's it?
No, sexual assault of a child.
Okay, in both, those are the only 2 right now where we don't have a statute of limitations?
Statute books over there, I'd have to look.
That's
but
okay.
I mean, there are
just
a
wonder-
couple
I
others.
appreciate, this is a horrible thing to do, right?
Sure.
But we do have a policy reason for having statutes of limitation, and I just wonder if this is on par with like a first-degree murder.
I would say that.
It's bad to be sure, but as a chair of Judiciary Committee, there's a lot of bad things that we see, and there can be, taking money from old people and violating people's trust and all kinds of things. And I just wonder if we are maintaining the appropriate balance, if you will.
If I can answer that, just.
Yeah, no.
I guess my opinion would be, the reason why, for instance, sexual assault of a child, the legislature crafted that out. I've gone back and I've reviewed the legislative history. And again, one of the things that I think the legislature was cognizant about when they designated sexual assault of a child to have no statute of limitations is the fact that we do know now about repressed memories that we didn't know about before. And so when children are the victims of crimes, horrible crimes like being forced into prostitution, we want to give them an allowance in order to come forward and tell their stories and have some means of justice available to them. And so that's why I think that to be consistent, these types of horrible offenses committed against children, knowing the fact that a lot of them will not initially come forward, and we're dealing with the Catholic Church situation right now, and
Sure.
I've got people coming forward from the 70s talking about things that they never addressed before in the past. And so I think that is the rationale behind it, and we wanted to stay consistent with what.
So the statute of limitations has really 2 policy bases. One is that a person at some point ought to have some peace, right? They ought to have it behind them, and that's both in the criminal world and in the civil world. But it's also about the availability of evidence, right? So somebody could have, were we to accept this bill and make it the law, 30 years later, somebody's bringing a charge, and now, they can't find they don't know where they were on April 26th and 30 years ago.
I'm not saying they're easy cases to prosecute or defend,
Right.
but in some cases they can be, and they can be brought, especially with the way that technology is archiving things, and things are becoming a little bit easier to do those. But I get the challenges, and I think, one of the things that the statute of limitations recognizes is that some crimes are so reprehensible, and we understand potentially why certain victims may not come forward, that's why we crafted out a narrow exception.
I don't know the answer to it, other than as soon as, I just don't want to have statute of limitations creep where pretty soon we say we're done with statutes of limitation and anything's open forever.
And I don't think that's our purpose. It's just in specific limited exceptions when we're talking about minor victims that have been subjected to horrific things.
Right, okay. Senator Panzing.
Thank you. Just to follow up on this, Mr. O'Brien, so I believe we have, you said the statute of limitations, we have no statute of limitations on sexual assault of a child. So human trafficking is sexual assault of a child. So
Agreed.
it's pretty darn consistent with our current laws and the fact that our really sea change that has occurred in the past 5 years of understanding that we have been arresting the wrong person for a number of years. We've been more focused on the victim than we have been on the trafficker or the purchaser or the actual criminals. And, just a couple of years ago, we defined that, before 3 years ago, we were still prosecuting and arresting a child for prostitution, even though they cannot have the consent necessary to commit that crime. So clearly, we've made a huge change, and I just want to clarify for the record that this is not inconsistent with our current laws. It's not really an expansion of the law. It's an understanding that a child is really vulnerable and may tamp down some of things, may not understand what's really happening until much later. And so they have to have an ability to, obviously we want to protect any kind of erroneous charges against a perpetrator, but we also ought to allow the child to grow up and understand what really happened to them in adult terms. Thank you.
Thank you, Senator. You said it much better than I did, and I want to thank you for all that you've done in this area. Before you got to the legislature, there was very little in the way of human trafficking awareness and legislation, and I also want to thank Senator Slama for agreeing to carry this bill for us.
Okay, I don't see any other questions. Thank you. Next proponent.
Good afternoon. Chairman Lathrop and members of the Judiciary Committee, my name is Megan Malik, M-E-G-H-A-N-M-A-L-I-K, and I am the Trafficking Project Manager at the Women's Fund of Omaha. I'm speaking today in support of LB 519 to lengthen the statute of limitations for prosecuting the trafficking of both minors and adults. I want to thank Senator Slama for bringing this really important bill forward, for also signing on to the critical package of trafficking bills this year, not only before this committee, but also in the HHS committee. Of course, I want to thank Senator Pansy Brooks for her tremendous leadership, for co-sponsoring this bill and leading other bills and really leading the legislative fight against trafficking. 519 will increase opportunities for justice and offender accountability, as well as provide law enforcement tools for investigation and prosecution of traffickers. Trafficking survivors pursue a number of paths to heal from their experiences, such as substance abuse recovery, mental health counseling, work in anti-trafficking initiatives, or seeking justice and accountability for the traffickers who exploited them. Unfortunately, the option for justice is often unavailable to survivors in Nebraska because our current statute of limitations bars survivors from pursuing legal action if they were victimized more than 3 years ago. 3 years is an incredibly small amount of time, particularly given the nature of trafficking. Survivors of sex trafficking endure tremendous pain and trauma while trafficked. Trafficking survivors suffer painful health consequences from their victimization. One study found that 62% of survivors experience PTSD, 81% develop depression, and 96% suffer from any number of psychological health problems. Due to the severe physical and emotional abuse survivors endure, fear of retaliation by their traffickers, and confusion over complicated legal proceedings, many survivors do not pursue justice within the legal system until after Nebraska's 3-year statute of limitation has passed. I'll just note, I think that this is accurate, but I believe that all first-degree sexual assault has no statute of limitations. So I would say that this would be really consistent, this law, with existing laws on our books. Passing LB 519 and lengthening the statute of limitations for trafficking offenses will give survivors the pathway they deserve to legally hold accountable the individuals who have raped, tortured, and exploited them. 23 states have already eliminated statutes of limitations for criminal trafficking prosecutions entirely. Our neighbors have also increased their statutes of limitations for trafficking. Survivors in Wyoming, Colorado, North Dakota, South Dakota, and Missouri all have 7 or more years to pursue legal action. Passing LB 519 will aid our anti-trafficking efforts in numerous ways. It will provide survivors with an opportunity to hold their traffickers accountable and seek justice. It will allow law enforcement and prosecution more time and resources to protect Nebraska citizens. And lastly, it will send the message to survivors, traffickers, and ordinary citizens across the state that Nebraska will not tolerate the sexual exploitation and abuse of its people. We respectfully request the Judiciary Committee advance LB 519. I'm happy to answer any questions.
I don't see any questions, but thanks for being here today.
Thank you.
Good afternoon.
Good afternoon, Chairman Lathrop and members of the committee. My name is Nate Graz, N-A-T-E-G-R-A-S-Z. I'm the Policy Director for Nebraska Family Alliance and would like to express our support for LB 519. This legislation helps ensure justice for victims of heinous crimes, the trafficking of children and possession of child pornography. By passing this bill and extending the statute of limitations for trafficking of adults and children and for the possession of child pornography, the state can recognize the severity of these crimes and ensure that our laws reflect Nebraska's commitment to ending human trafficking in our state while protecting women, children, and all citizens. LB 519 also empowers law enforcement to go after both traffickers and buyers by providing an option for the authorization of law enforcement to use wiretaps to intercept communications relating to trafficking. This proved useful and effective in disrupting trafficking rings just recently when a major trafficking investigation in Florida, which has received national attention, led to the breakup of a large-scale trafficking ring spanning multiple states and countries. This committee needs no reminder of the severity of this issue or its presence in our state. So I would simply like to extend our support for LB 519 and thank Senator Slama for introducing this bill, as well as Senator Panzingbrooks for co-sponsoring, and commend the Judiciary Committee's tremendous efforts as a whole to better combat trafficking and ensure justice for survivors in our state. Thank you for your time, and we respectfully encourage the committee to advance LB 519. Thank you.
Very good. Thank you. I don't see any questions. Anyone else here to testify as a proponent? Anyone here in opposition to LB 519? Good afternoon.
Good afternoon, Chairman Lathrop and members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is spelled E-I-C-K-H-O-L-T, appearing on behalf of the Criminal Defense Attorneys Association opposed to LB 519. The portion of the bill that we are opposed to is the lengthening and primarily the elimination of the statute of limitations. If you look on page 4 of the bill, lines 17 through 27, that's the portion of the bill that would eliminate the statute of limitations for the two offenses that Senator Salama mentioned earlier. Statute of limitations serve a purpose. Mr. O'Brien was correct that older cases are difficult to prosecute, but they're also very difficult to defend. That's one consequence of, or one purpose of a statute of limitations. It provides some sort of finality for life, if you will, that a person can sort of move on and they're no longer in danger. Another consequence or another purpose that statute of limitations provide is that they serve as a motivating factor or a reason for the prosecutor to actually charge a case. In other words, the legislature really cannot directly compel prosecutors to bring charges against anyone. If the state has the evidence, it's up to them when to choose it. The statute of limitation is sort of the motivation. A prosecutor can't sit on other charges beyond 3 years or 5 years or 7 years, depending what the statute of limitations is. If you remove that, there is no impetus, there is no motivation for a prosecutor to bring a charge. And that goes back to the first sort of reason for it, and that is at some point a person ought to be free of risk of prosecution. Now I know it's difficult when you're talking about this subject to simply say no or not to extend or eliminate it. But if you look at the list that we have now, and this is the reason our association opposes the elimination of statute of limitations, because once you start going down that road for one offense, it's so much easier to do it for other offenses. If you look at the current list now, We have it, no statute of limitations for treason, murder, and that would make sense. I think that Ms. Malik said that there is no statute of limitations for sexual assault of a first degree, and she's correct, there is none. But we also don't have it for arson or forgery. At some point, for whatever reason, that was important to the legislature, and maybe it was as important as this subject is now. And I don't mean to compare the two or to diminish the seriousness of human trafficking, but I'm just saying, for whatever reason, those two categories have no statute of limitations. It's a very easy step to simply add more and more crimes to it, and that really relates to our reasons for opposing the elimination of the statute of limitations. I did mention that to Senator Slama earlier today. So for that reason, we are opposed to that portion of the bill.
Senator Pansing Brooks.
Thank you, Mr. Eichel. I'm trying to understand what is the difference in your mind between sexual, I mean, we could have said, it could have had sexual assault of a child, comma, including trafficking in the first degree. I mean, if you want to argue it, a child that has been trafficked is raped multiple times. So I'm just trying to figure out why the differentiation between a child who's been sexually assaulted in the first degree and a child who's been trafficked.
If you look at, it's not just sex trafficking of a minor, but it's also labor trafficking of a minor. Those are ongoing commissions. In other words, a sexual assault is an act. The date can be pinpointed. If you're attempting to defend a person charged with that, you might have an alibi that could point to that date. You might have a witness who may be able to remember what was going on 30 years ago. When you have the ongoing crimes of trafficking, either labor trafficking or sex trafficking, those are more difficult to defend, arguably, and that could be one reason for the distinction. I understand there probably isn't a reason, but I think we oppose eliminating statute of limitations probably for the sex trafficking, or for sexual assault as well, for similar reasons. And we're perhaps equally successful.
Well, I can understand maybe, I mean, there could be some discussion about labor trafficking depending on what that was.
Right.
But if you've seen things like the boys in the tent or whatever that story is about some mentally challenged people in Iowa that were forced to live in very subhuman conditions and continued forced to work for little to no pay and not able to see their families, not able to eat appropriately. And so I don't know. I think that's just, you know, if you'd come in just on the labor part of it, maybe I could have sort of gone with you on that. But as it is, it should comply. Our statutes should coordinate, in my opinion.
I mean, I'm not disputing what you're saying, but the reason is that we're opposing is more basic because you have this very clear illustration of how horrible sex trafficking is on one side, and then you have forgery on the other, and there's just such a gap. It's just such easy, once you start going on, it's just so easy to add to that list.
Why don't you have us bring another bill?
Well, that's probably true, I suppose. But
Okay, thank you, Mr. Eichel.
I think that's it. Thank you for your testimony today. Anyone else here to speak in opposition? Anyone here to testify in a neutral capacity on LB 519? Seeing none, Senator Slama, we have no letters on this, so you're good to close.
All right, I'll be brief. I just wanted to thank Senator Pansing Brooks for her work that started long before I got here on this issue and for co-sponsoring this bill, and I thank the committee for their consideration on LB 519.
Thank you, Senator Slama. I appreciate it. I don't see any other questions. That'll close our hearing on LB 519 and bring us to LB 173 and Senator Pansing Brooks. So if you are going to speak as a proponent, if you wouldn't mind filling up the front row so we can, and otherwise coming down so we can keep the hearing moving along. We are welcome, Senator Pansing Brooks.
Thank you. Thank you, Chairman Lathrop and fellow members of the Judiciary Committee. For the record, I am Patty Pansing Brooks, P-A-T-T-Y, P-A-N-S-I-N-G-B-R-O-O-K-S, representing District 28 right here in the heart of Lincoln. I am introducing LB 173 today to create a yes means yes standard so that victims of sexual assault are better protected under the law. The yes means yes standard is also often known as affirmative consent. Last year, I felt that it would be particularly appropriate to introduce this bill in light of the hashtag #MeToo and the hashtag Time's Up movements. Since the original bill, I've been fortunate to work with county attorneys and others, and we reworked some of the language to better fit with existing statutes. Affirmative consent is knowing, voluntary, and a mutual decision among all participants to engage in sexual activity, according to Chandler Delamater with the Albany Law Review. Consent can be given by words or actions as long as those words or actions create clear permission to engage in sexual activity. Silence or lack of resistance in and of itself does not demonstrate consent. The definition of consent does not vary based upon a participant's sex, sexual orientation, gender identity, or gender expression. This is exactly what this bill is working to address. This bill is more than a definitional change. This bill is about empowering survivors of sexual assault who seek justice from their attacker. It does not change the intimacy of consensual sexual activity. Instead, it reframes the way our legal system will approach situations in which individuals did not give voluntary, conscious, and mutual consent in sexual encounters. Under this bill, consent is present when it is knowingly and voluntarily given, either verbally or through overt actions. When there is no indication through words or conduct that someone is willing to engage in an intimate encounter with another, consent has either not been given or has been withdrawn. It is important to remember that consent can be withdrawn at any time if either participant feels unsafe, threatened, or violated. Regardless of previous or current relationships, consent must be present before engaging in a sexual activity. And I would add that if someone is confused and claims that they need notarized evidence, it might be time to find a new partner. In 2017, Montana enacted a law similar to the one before you today, as their statutes at the time did not account for victims who were unable to consent due to freezing during the attack. Missoula Deputy County Attorney Susie Boylan has pointed out that offenders were able to take advantage of victims who neither said yes or no before Montana implemented their affirmative consent law. For those who think that this may not be a relevant, or who may not think that this is a relevant problem, I want to take a minute to stress the importance of action on this issue. Delamater from the Albany Law Review has stated, it is still the case in many jurisdictions today that a mere lack of consent is insufficient to establish rape. In fact, a constituent of mine reached out to my office regarding this piece of legislation to express her support. She explained that as a juror in a sexual assault case, her jury had trouble convicting the alleged attacker in the case due to the fact that the victim never said no, though she also never said yes. Consent is not passive. The current no means no standard presumes that when there is not a no, sorry about the double negative, but when there is not a no, then there must be a yes. It implies that an individual, often a woman, that we are all constantly consenting to have sex unless we are able to say no. Under the no means no standard, we are in a constant state of acquiescence to sex unless we say no. That just makes no sense, really. I want to stress that this bill does not put the burden of proof on the person who has been accused. Bobby Villarreal, Executive Director of the Dallas Rape Crisis Center, has explained that, quote, rape is the only crime in which we turn the lens onto the survivor, the victim, and not onto the perpetrator. When someone gets shot, we don't ever ask them, why didn't you get away from the bullet? Right now, the burden of sexual assault falls squarely onto the shoulders of those victims of this terrible crime. unquote. This bill can give survivors the courage to come forward with the knowledge that they will be protected under better standards for consent. And we will not have their cases dismissed because they were so brutalized, unconscious, or threatened that they could not say no. There are some that will claim that this is just another he said, she said, but tightening the definition of consent does not change that legal issue either way. That's why we require county attorneys to prove their case. I do have one amendment to the bill from the Attorney General's office, Amendment 105, will tighten up the language and avoid potential misinterpretation of the words, quote unquote, freely given. Finally, for those of you that may be struggling with this different way of approaching consent, I want to refer you to a video, and I hope you'll see it online, but I have passed it out to you, and it's a fabulous video, especially if you listen to the British version, because it's about consent as compared to getting a cup of tea. And I've sent it out to you. Last year I read it to you, but I know that there are things that are in our future that people want to attend at some point, so I'm not going to read it all out to you. But in summary, it talks about how consent is as simple as a cup of tea. If you offer someone a cup of tea and they say, yes, that would be wonderful, then you can give them a cup of tea. If someone did not want a cup of tea, you would not force them to drink it. Sometimes people even change their minds and first say they would like a cup of tea, and then while it could be annoying, because they prepare the tea for you and they warm the milk, you should not force them to drink that tea. And there is no way that someone who is unconscious could ever answer that they don't want a cup of tea. So there's no point of even making them tea. Clearly, people who are unconscious do not want tea, and I would add, do not want sex. And just because they did earlier. So just because you made someone tea last week doesn't mean that they would want it the next time they see you. So if you can understand that about a cup of tea, I think that you can understand that the same thing should happen with sexual relations. So I ask you to advance LB 173 and Amendment 105 to general file. And again, let me be clear that somebody questioned again, well, gosh, it's he said, she said, what are we going to do about that? And my point is, if you think you need a notarized agreement to prove that you have consent, then maybe you need to find a new partner and probably shouldn't go forward. And I'd like to thank Brody Weber, who's an intern that came to me with this bill a year ago. He's an amazing young man, and he has worked on this for part of his senior thesis, and I hope you'll enjoy listening to his vision and brilliance on this issue. Thank you.
Thank you. I do not see any questions. First testifier.
This is for the committee.
Good afternoon.
Good afternoon. Thank you, Chairman Lathrop and members of the Judiciary Committee. For the record, my name is Brody Weber, B-R-O-D-E-Y-W-E-B-E-R, and I will be speaking in favor of Legislative Bill 173. In fact, this bill is quite personal to me, as I've been working closely with Senator Patty Panzing-Brooks and her extremely talented staff for both last year and this year, and thank you for your kind words, Senator. I would like to share why I care so deeply about affirmative consent and the standard. I proudly attend the University of Nebraska-Lincoln as a junior in political science, as well as communication studies. In communication studies, we learn gender communication, and that involves sexual activity. Starting college a few years ago was an exciting and intimidating challenge. Luckily, because of my great network of friends, I had a strong support system. My friends were always there for me, and I tried in turn to always be there for them. One of my best friends is an incredible person, and then for the interest of her privacy, I'm going to refer to her as Olivia. In May of 2017, I had to be there for Olivia as she became another addition to a terrible statistic. She was sexually assaulted by an acquaintance, someone who we all knew, while she was attending a social event off campus. Olivia and our friends ran into this person while I studied for my very last final of my freshman year. That next morning, I woke up around 5 a.m. to a phone call, and this was not a normal call from Olivia. She had lost her bubbly tone, her infectious optimism, and her knowing humor. For the first time since I had met her, Olivia sounded broken. Right then and there, I knew something was wrong and something had to be done. Later that day, she underwent tests and interrogations I would never wish upon my very worst enemy. When I asked her why she would not go to the authorities to seek the justice I felt she deserved, it was because she did not say no during the assault. I continued to ask her other questions, and she never once said yes. And in fact, her actions showed that she was not welcoming the activity. Olivia was unable to say anything, and while her voice was unheard, she was attacked. And I would say she passively resisted, as this piece of legislation is working to do. Though she did not say no, she tried resisting. And I find that loophole disturbing and unacceptable, and that's why I'm here for not only Olivia, but survivors of all sexual assault. I also want to note that according to Delamater in the Albany Law Review, he states that we need to no longer teach people to look for the no, but rather to look for a yes, whether it's confirmed verbally or you have to remember through overt actions. Actions can indicate consent if they are overt. Before I go, and then one last thing. Senators, I want to leave you with this one final thought. Every day you walk these halls and you have the incredible opportunity to create history. Today you get a choice. You get to choose if you are on the right side of history, and you get to choose if you are going to fight for survivors like Olivia and for their justice, or to maintain a system that leaves far too many voiceless. I have confidence in all of you to make the right choice for Olivia and all of the other Olivias out there. Thank you so much for your time, and I would love to answer any questions that you may have.
Thank you, Mr. Weber. Does the committee have any questions? I don't see any.
All right. Thank you, Senator.
Next proponent.
Thank you, Judiciary Committee. My name is Lexi Karkazis, Lexiekarkazis. I'm currently a sophomore computer science major at the University of Nebraska-Lincoln. I'm a member of Delta Gamma, a Panhellenic sorority at UNL. I serve as the Vice President of Programming and Membership Development on the Panhellenic Executive Council, which oversees the Panhellenic sororities at UNL. Part of my job is overseeing risk management, so I am here on behalf of the Panhellenic community to express why we're in support of LB 173. Coming to college is one of the most exciting yet confusing transitions in life. Many women choose to join a sorority, which not only brings them into one chapter sisterhood, but the Greek community as a whole. This large new social scene can bring tons of fun memories, but also unexpected situations. I personally know many women who have been put in compromising positions and have not known how to react when someone is pressuring them to partake in acts they do not want to partake in. It becomes very hard to say no and fight back when someone is coercing you, using fear tactics,